Okay, looks like we're right at 10 o'clock. Good morning. Welcome to another Zoom session of oral argument of the 5th DCA. I'm Judge Lambert from Marion County. I'm presiding today. Our panel, you see on the screen, Judge Cohen from Orange County and Judge Harris from Brevard County. This is case number 19-2176, Juan Saavedra versus Universal Property and Casualty Insurance Company. Okay, each side will have 20 minutes. Ms. Berger will have a 5-minute default time for the rebuttal, and she would tell me you want some different time, and we'll have the timekeeper adjusted accordingly. And again, we are being streamed on YouTube, so our vast audience, I'm sure, are watching us. So keep that in mind when you make any comments or make your arguments to us. That being said, it's 10 o'clock on the nose. So Ms. Berger, whenever you're ready, go ahead.
Thank you, Your Honor. May it please the court, Aaron Berger on behalf of the appellant Juan Saavedra. The 5 minutes rebuttal time is sufficient, I believe. And in this case, the appellant requests that the court reverse the entry of a final summary judgment based on procedural and substantive errors that occurred below. I'm sure your honors are familiar with the facts of the underlying matter, that it was an insurance property claim. And Mr. Saavedra filed a breach of contract action against Universal when determination wasn't made as to its claim. Relevant to the issues that I want to discuss initially are the fact that there was an amended complaint filed in December of 2014, and thereafter, and 2 years later, February of 2016, an answer to affirmative defenses was filed in which, in response to plaintiff's allegations that he had complied with conditions precedent, the insurance company generally alleged that they denied it and demanded strict proof thereof. They did state an affirmative defense, generally averring that Mr. Saavedra had not complied with conditions precedent. Mr. Saavedra argued below and maintains here today that the defense has not been sufficiently pled under the Florida Rules of Civil Procedure and should not have been considered by the court for a basis for summary judgment. Universal failed to properly plead compliance with conditions precedent. In the motion for summary judgment—
Let me ask you, Ms. Berger, did the plaintiff move to strike the affirmative defense below?
No, but I don't believe that that's a requirement. There's nothing in the rule that says that they have to do that. The case that was cited by Universal in its answer is kind of an anomaly that hasn't been widely accepted, hasn't been further applied within its own district in the third, and it was distinguishable on its facts. The case that we've presented in our initial brief and again in the reply brief was a case from this district in Gottschalk, which was several years, almost 15 years after the Calero case cited by Universal, in which there was no requirement that the plaintiff move to strike or request a better pleading or an alternative pleading or any sort of better explanation for the defense. In Gottschalk, this court stated that the purpose of Rule 1.120 is to put the burden on the defendant to identify the specific condition that the plaintiff failed to perform so that the plaintiff can be prepared to provide proof and cure any omission if possible. The Calero case was distinguishable because in that case, the defendant specifically cited to a specific statute that wasn't complied with. It's only been cited again by 3 cases, none of which hold that particular holding that it's a requirement that the defendant move to strike or require a better statement.
In Calero, the court itself, and I think footnote 3 said, since plaintiffs there did not allege performance of conditions preceding, there was no occasion for the county under 1.120C to actually file the particularized denial that you're talking about here. And your case here today is a little different, I guess, because you did generally allege compliance with conditions preceding, and
Correct.
That triggered the defendant's obligation, according to your argument, under 1.120C to make a particularized, which condition preceding do you say I didn't comply with,
Correct. Correct, Your Honor. And we did mention
And,
that.
and this was actually, you raised this in response to the motion for summary judgment, if I recall. This is one of your defenses to it. And if I understand the chronology, that was like in June of 2008, and the summary judgment hearing for some reason didn't take place till June of 2019. So
Correct, Your Honor. The motion for summary judgment was filed in May of 2018. They filed an affidavit in response a year later, but plaintiff's response to the motion for summary judgment was filed within 30 days of their motion for summary judgment.
well, in
And
other
they
words,
raised that
you
specifically.
raised the pleading issue in your response, and the defendant then had the option to say, oh, I'm going to cross all my T's and dot my I's, or whatever the alphabet is, and move to amend my affirmative defense to more particularly say you didn't comply with this one, and this one under the conditions proceeding under the policy. And they, I guess, didn't do that. There's nothing in the record that shows that they did that, right?
Correct, Your Honor. And that's exactly the point. They had over a year to cure their deficiencies in their pleadings and took no action to do so. And at the hearing, Your Honor, they took the position that they didn't even have to do that based on the 1500, the number is all I can remember, 1500 condo case. But in that case, that was a case where an answer wasn't even filed. And we're not arguing that they have to file an answer before they file a motion for summary judgment. But when they do file an answer before they file a motion for summary judgment, they have to comply with Rule 1.120 and Rule 1.140 to particularly plead compliance with conditions precedent. And they didn't do that here. So the trial court should not have considered and should have denied the motion for summary judgment on the basis that, as Your Honor pointed out, was raised in response to the motion for summary judgment more than a year prior to the hearing, and was argued at the hearing as well.
And that in your mind, that's dispositive here. I mean, you have other issues and they respond to other issues, but your argument, I guess, if I understand, is we could reverse just on that alone and send it back, and then everybody proceed forward with, I guess, amending the answer and going forward.
Absolutely, Your Honor. It is dispositive. And there's cases that I cited, the Godshot case and its progeny within this court and throughout the state of Florida. There's
So
another.
with Lawson and Torpy in the majority in that Godshot case, do you think that's persuasive to anybody? Should that be binding on us? Look at those two who wrote it. Geez, really?
Well, I mean, I know. Torpy was a gentleman and a scholar. And,
no one ever referred to Vince Torpy as a gentleman.
Yeah, maybe the scholar part.
Scholar part.
We put gentleman up there.
Fun fact: I used to carpool with Judge Torpy.
Oh.
I know, and we feel for you.
Yeah, he was a good man. But the Gottschalk case, Your Honors, is dispositive of the issue here. There should not have been consideration of these defenses. Again, we're talking about a policy that's 36 pages long, a particular provision with regard to the post-loss conditions that contains 8 subsections, and then multiple subsections of those 8 sections. Without that pleading particularity, which was, the insurance company had plenty of notice of, the judgment in this case that was entered on their motion was procedurally improper. As Judge Lambert has stated, our argument is that issue is dispositive of the issues here. Our initial brief does contain multiple other issues that address the substantive issues that were decided by the court in its summary judgment, in that the judgment was not warranted because, based on record evidence, and this is one of our more minor arguments, but based on record evidence, the affidavit that was filed by the insurance company, the corporate representative stated that, at the time they did their inspection in March of 2014, he alleged that there was evidence that it wasn't even covered anyway. So this seems to be more of a situation where they were trying to catch the plaintiff in a situation where he couldn't comply with the post-loss conditions. And they still had enough information to make a determination, but didn't in order to catch him in this way. We've also alleged that there are genuine issues of material fact related to whether or not the timing of the notice was proper and appropriate under the terms of the policy, and whether or not the other unpled conditions were complied with, and whether or not there's prejudice that resulted from these alleged non-compliance with these policy terms. With regard to the timeliness, it is undisputed that the loss was not given, notice of the loss was not given until February after a November loss. However, there's genuine issues of material fact because Mr. Saavedra's deposition suggests that he may just not have known that the severity of it until the point at which he gave notice. And as he said in his deposition, he thought he cleaned it up. He thought the issue was resolved and didn't think much of it. And he, much was made by the trial court and by Universal in the trial court below that he didn't seem to know much about this, but I would have this court note that in the record, there's no suggestion that they did any sort of request for an EUO prior to the filing of the complaint or at any time during their investigation. And they didn't take his deposition until almost 5 years after this had taken place. The record evidence shows that he did provide them with the information that he had, including a receipt that shows that he did, there was something that happened on the date of the loss as reported. The cases that have been cited by the insurance company below and in their answer brief here suggest that there's some sort of bright line rule that when there's a passage of time, that there's no genuine issue of material, passage of time between the loss and when it's reported, that there's no genuine issues of material fact that could ever be found. But again, there are situations where, as Mr. Saavedra stated in his deposition, that he just may not have realized that he had a claim until a later date. And the cases that were cited, and I point this out in my initial brief, this is not a case where he waited years upon years upon years to report a claim. It was just a few months and happened to be within a time period of another loss. This case, or this court has stated, and in some of the cases cited in my briefs, that a failure to timely report a claim or the breach of a duty to cooperate gives rise to the automatic forfeiture of an insurance benefits absent prejudice to the insurer. I've cited Curtis in my brief from the second DCA that says the same thing. Again, going back to the fact that, the corporate representative was able to say, we didn't think we were going to cover this anyway, that suggests that there may not have been any prejudice as a result of these alleged non-compliance issues. The insurance company also claimed that they were prejudiced by not being able to review or to see any sort of broken fixture or piece of the air conditioner. But the policy doesn't require that the insured maintain these pieces or this particular anything that's remediated. The policy actually requires them to take remedial measures to prevent further damage, which he did here. And then he's punished for having made those remedial damages by not being able to show this quote unquote damaged property as the insurance company would have this court find that it is defined. The record shows here that Mr. Saavedra did cooperate to the extent that he could in, reporting it when he found out there was an issue or he realized there was an issue, allowing the inspection to proceed, giving the documents that he had available to him, and trying to do what he could to assist in the investigation. There's case law that I've cited that says any ambiguity in the terms of the policy should be resolved in favor of the insured. And we would suggest that, if the insurance company is suggesting that damaged property be, defined in a certain way or prompt notice be defined in a certain way, that takes away the issues of material fact from the jury's determination here that those issues should not have been resolved on summary judgment. Finally, we argued that the insurance company did not meet their burden of proof. The trial court suggested found in its order that because no affidavit in opposition was filed, there wasn't any evidence or any reason for him to not side with the insurance company, essentially. But we maintain that Universal failed to meet its burden of providing competent evidence. The documents that were provided in support of the summary judgment were merely attached to the motion, which is insufficient under the law. In their answer brief, they suggest that the corporate representative affidavit that was filed a year after was sufficient because it identified those documents. However, I've cited a case in my reply brief that Richard versus Asset Management that demonstrates that this isn't sufficient. An affidavit without any business records attached to it is insufficient to meet the burden under Rule 1.510. And also, even if the court were to properly consider that, it still didn't have any sort of language that would be required under 90.8036 to authenticate those records that were merely attached to the motion. And unless the court has any additional questions for me, I'll await my rebuttal time.
Okay, thank you, counsel. 5:42 left, 5:41.
Thank you.
Okay, Ms. Alvarez, whenever you're ready, ma'am, go ahead.
Good morning. May it please the court. Maria Alvarez on behalf of the Applee Universal Property Insurance Company. Your Honors, the record before this court shows that the appellant's AC drain pipe allegedly leaked on November 12, 2013, causing visible water to form a puddle through certain portions of his home. Appellant called the AC repair company that visited the property about 2 days after the leak, and they made a complete repair of the AC. Appellant does not know the repair company's name, does not know what parts of the AC were repaired, has no recollection of how much the repair cost, and saved no documentation or photos evidencing.
Ultimately, their case might or might not be a very strong case, but let's talk about the issue of whether the affirmative defenses were pled with sufficient specificity.
Sure. First, I want to just speak to the issue of whether the plaintiff had an obligation to file a motion to strike. The Rule 1.140 subsection B is very specific. The last sentence of that rule says, and I'm quoting it, except that the objection of failure to state a legal defense in an answer or reply must be asserted by motion to strike the defense within 20 days after service of the answer or reply. Appellant plaintiff was obligated to file a motion to strike. They failed to do that. So as a result of their failure, they waived any argument as it relates to the sufficiency of the pleading of the affirmative defense. What the case law cited by appellant in the motion.
I had the rule earlier today, but give me that rule again.
Sure. 1.140 subsection B, the last sentence of that subsection.
Okay. All right, go ahead.
Okay. All of the cases that appellant cites in their brief to support the contention that Universal did not sufficiently plead their affirmative defense are all cases where either a plaintiff was moving for summary judgment or a plaintiff at trial was presenting its case in chief. So in those cases, the defendant either failed to specifically deny the general allegation, which Universal did in this case. We specifically denied the allegation that plaintiff had complied with all condition precedent, or that defendant was attempting to avoid a summary judgment by saying, hey, judge, the plaintiff did not dispute or did not put forth any evidence to rebut my affirmative defense. So in those cases, it was the plaintiff who had the burden of proof. For example,
Can we go back to your 1.140B position?
Sure.
I mean, looking at the last sentence, except that the objection of failure to state a legal defense in an answer, et cetera, must be asserted by a motion to strike the defense.
Mhm.
I mean, your defense is a legal defense. It's just not properly pled. So you're saying that you have your interpretation of the rule is every time that a legal defense is asserted, but it's not asserted sufficiently, you must move to strike it?
You're saying that the way that I interpret the appellant's argument is that my defense wasn't legally sufficient because it wasn't properly pled. And so, yes, they should have moved to strike, or they should have moved for a more definite statement, or they could have propounded discovery on Universal asking for more information related to that defense.
Well, the lack of
The
lack of a condition precedent is a legal defense. And how would you distinguish, the case law that Ms. Berger cited out of our district that seems, fairly clear that you have to be specific in setting forth which condition precedents were not met?
Sure. Let me and I'll get right into that. The Godshaw case, which is, I believe, the case that you're discussing, that was an appeal of a summary final judgment in favor of the bank. The bank had moved, the plaintiff had moved for a summary judgment. In an effort to avoid the summary judgment, Godshaw had denied in his answer that the bank had complied with all condition precedent. If you actually look at the opinion and read the dissent from Judge Griffin, there's a discussion of how that pleading was outlined, and there's actually no discussion of the affirmative defense. Godshaw wasn't moving on his affirmative defense. He was defending, attempting to avoid a summary judgment by saying, hey, judge, I denied paragraph 8. And they found that the denial was insufficient. That's not what we have here. We don't have, plaintiff was not moving for summary judgment on their breach of contract claim. And then Universal was saying, hey, judge, we denied, look at paragraph 8 where we denied that they met conditions precedent. Universal was moving on its affirmative defense for motion for summary judgment. Procedurally, that is the complete opposite of what happened in this case. And plaintiff's argument, appellant's argument, in their reply, the gist of it is that they didn't get notice of what conditions precedent we were moving for under. But if you read our motion for summary judgment, it outlines the 4 reasons, the 4 post-loss obligations that appellant did not comply with. So if notice is the issue, that was satisfied in the motion for summary judgment. And the appellant had a year before the hearing to either take discovery or to file some opposition with evidence that showed he complied with his post-loss obligations, and that wasn't done.
On the flip side, you had a year to amend your motion, right? Or amend your defenses.
But we were never ordered to amend because there wasn't either a motion to strike or a motion for more definite statement ever filed. A response in opposition to a motion for summary judgment does not place the burden back on the defendant to amend its pleading.
Well, it does maybe if you're wrong on the law. If they were right and they put you on notice and you had a year to fix it, which looks like what might be the case here, you had a year to amend that affirmative defense to say exactly which conditions precedent were not complied with or how they were not complied with.
Well,
they didn't. This wasn't a sandbag. They didn't sabotage you and bring this up the eve of summary judgment hearing.
No, that's not my argument. My argument is that procedurally, the Godshaw case is not on point with this case, because in that case and all the other cases that appellant recites to are cases where the plaintiff was either moving for summary judgment or it was at their case in chief at trial, where the defendant then went and said, hey, judge, plaintiff didn't prove their case because they didn't prove that they comply with paragraph 22 of a mortgage. But the defendant's answer never cited to paragraph 22 of the mortgage. That's not what we have here. What we have here is a defendant.
The rule here contemplates that the affirmative defense needs to be specific. And it doesn't say if it's not, you can correct this by putting it in your motion for summary judgment. That's not really an option that's authorized under the rule, is it? But you can, if the issue is notice, you can fix that notice by telling them what they've done wrong in your motion for summary judgment.
Well, that's when I would say that the Calero case is more on point than any of the cases that the appellant has cited in their answer brief, because in that case, it's a case procedurally on point where a defendant was moving for summary judgment and the plaintiff came back attempting to avoid the summary judgment by saying the defense wasn't sufficiently pled. And the court said, no, you waived that argument because you did not file a motion to strike or a motion for more definite statement. You did not propound discovery asking for more information. So you cannot come back and say you didn't have notice when the motion for summary judgment there's no dispute in this case that the motion for summary judgment didn't outline the basis for its reasoning of the post-loss obligations. That motion specifically identified 4 reasons why appellant did not comply with the post-loss obligations: prompt notice, failure to provide documentation, failure to show the claim damage, and failure to comply with all post-loss obligations. That was clearly outlined in the motion for summary judgment.
But what Judge Harris is saying is, and if I'm following the theme here, those would have been really nice things for you to put in your affirmative defense, because then that would have put the other side on notice. This is what you all did not comply with. you can't cure that pleading deficiency. I mean, there's case law. You can't cure that pleading deficiency by setting it in a motion for summary judgment. Do you agree with that? There is case law. Do you agree with that?
No, I don't agree with that.
You don't
because
agree
the
with
case,
the case law that if you don't plead a defense, but then you can raise it on motion for summary judgment?
that's not the case here, Judge. All the cases that where they said that the defendant didn't plead an affirmative defense is because they actually didn't plead anything. There wasn't an affirmative defense at all. That's not what we have here. We have a written affirmative defense. In the cases that are cited in the initial brief where a defendant did not assert an affirmative defense, it's because it was completely lacking from the document, where they just denied either generally or specifically the condition precedent. They either said in their answer, paragraphs 1 through 8 are denied. And that's obviously not a specific denial. And it didn't
How is
contain.
that? Okay, so you denied an answer, but or else you raised an affirmative defense that says you didn't comply with the conditions proceeding. You're saying that that part's okay. If you do that, then you've met your burden of pleading. Whereas if you simply file an answer saying I deny all the allegations of the complaint, then you've not complied. You've not met that burden.
Yes, because it's the defendant's burden to plead their affirmative defense.
Okay, with particularity.
It's our burden, yes, our burden either on trial or summary judgment to plead our affirmative defense. It's not the plaintiff's burden to disprove my affirmative defense. It's if I were to say in my answer, denied, right? Allegation to condition precedent denied, plaintiff did not comply with all post-loss obligations, including failure to provide documentation. If that was just in my answer, taking out the affirmative defense. The plaintiff
the
then.
only case you cite for your position that there has to be motion to strike is this Calero case, right?
Correct, because procedurally that's the most on-point case.
And if we don't agree with Calero, then you really don't have any other DCA or any other court cases that suggest that that's the route that has to be taken. That's the route that should have been taken by the plaintiff here to address the insufficiency of this particular affirmative defense.
Not in my, with the exception of the 1500 Coral Towers case, I believe. I could be, because that.
I was looking at the actual, I think it's issue 2 in the briefing, and I just read issue 2 that you raised in response to the initial brief, and that's the only case that I see cited there.
Right. Yes, Your Honor. And then the other case, the 1500 case, which says we didn't even have to file an answer. We could have moved on summary judgment without asserting any affirmative defense, which I understand that's not exactly on point because we didn't assert an affirmative defense. But it's the whole purpose of this is the plaintiff on notice? And the answer to that question is yes, they are on notice of the post-loss obligations that we were traveling under, and they had an opportunity and notice to put forth evidence, which they did not do, to rebut our argument.
Okay.
So I
hear the words you've said. Whether you've convinced me is a different thing, but I understand the words you said.
Okay. I'd like to move on to the prompt to address the prompt notice issue, because I think that's the crux of the other part of appellant's argument as far as prompt notice. And I actually understood appellant's argument to be that they were focusing primarily on whether 3.5 months was an unreasonable amount of time, because they make a huge point to say that it's not an unreasonable amount of time, and it may not have been, but the case law cited by both parties in their briefs have found that a period of 6 weeks has been untimely, and that's the Ideal Mutual Insurance Company case versus Waldrop, and a period of 3 years to actually create an issue of fact, and that's the Lacker versus Citizens Property Insurance Company case. The purpose of a provision for notice is to enable the insurer to evaluate its rights and liabilities, to afford it an opportunity to make a timely investigation. That's the whole point of the prompt notice provision. As the court in the Ideal Mutual Insurance versus Waldrop case explained, when there's an occurrence that should lead a reasonable person to believe a claim for damage arises, notice becomes necessary. And while that's usually an issue of fact, if it is undisputed evidence will not support a finding that the insured gave notice as soon as practicable, then a finding that notice was timely given is unsupportable. And so if we look to the Yacht Club on Intracoastal Condominium Association versus Lexington Insurance Company case out of the 11th Circuit Court of Appeals, that court found that as a matter of law, the insured knew that the insured's notice was untimely. And they based that finding on the insured's own testimony, where he knew of the damage at the time of the occurrence, and he set aside funds to make repairs. Such testimony, the court found, was sufficient to lead a reasonable and prudent man to believe that a claim for damages would arise. Here, the appellant testified that he was aware of the AC leak. He saw water on his floor in November of 2013. So the supposed damage was known at that time. He had called an AC repairman to actually fix the AC. He had no other issues with the AC after that point. And without explanation for the delay, he had his counsel from the Strems law firm contact and report the claim in February. After all the repairs were made, no evidence, no photographs, nothing was ever retained. He has no knowledge about whether anything was ever retained, if he ever had documents. So comparing his testimony with the testimony that the 11th Circuit found sufficient in Yacht Club is sufficient to lead a reasonable and prudent man to believe that a claim for damages would arise. And so therefore the notice was not prompt, it was not timely. And then the burden shifted to the appellant to show prejudice, to show lack of prejudice on the insurance company, which they did not do. The only
What was
thing
the
that they
delay in the Yacht Club case?
It was a few years.
And this was 6 weeks, 3 months in our case?
Correct.
Is that a difference?
Correct. No, because the focus is not on the amount of time. Because if we look to, let me just get the case.
But timely is not really defined, right? The Labello case says whether it's timely is really a question for the jury.
It's under the facts and circumstances of the case. And what happened here in the period of 3.5 months was that the AC was fixed, the damage was repaired, there was nothing retained. And it's from the time that the damage became apparent. And in the Lacker case, it was a condiment.
It's a catch-22 though, because he's got a duty to mitigate his damages.
Right, but that's not conjunctive. He could do both of those things at the same time. He could have taken photos of the damage. He could have taken photos of.
Does the policy specifically require that?
It requires him to keep an accurate record of his expenses and of the repairs. And it's required to show the claim damage. And so whether you want to show it physically or you want to show it in photos, there's plenty of cases where an insured just takes photos and then experts later on review the photos to see what the damage was. All of that would have been possible.
Did he call the people that did the repairs to have them testify as to what was done?
He doesn't know the name of them. He doesn't know the name of the AC company.
Right.
He doesn't know how much the repair cost. He wasn't even home when the repair was made. He has no documentation. He doesn't even know what caused the AC to leak. He doesn't remember if the AC was working at the time of the leak. So we've asked these questions of him and we've gotten nothing in response. And the receipt that the appellant's relying on in order to create this genuine issue, this $4.35 Home Depot receipt, the appellant testified he doesn't recognize that receipt. He couldn't authenticate that receipt. He doesn't remember if it was even for something that he purchased. He doesn't remember providing it to his attorney. So the court, when faced with a motion for summary judgment and to look at the evidence that was offered to rebut that summary judgment, is either his own deposition testimony where he lacks complete knowledge of anything related to the claim. And that's not an exaggeration. I could go through all the pinpoint records of his deposition where he did not know what repairs were made, doesn't remember the cost, doesn't remember the name of the AC company, doesn't remember if he has any records showing what repairs were made, does not know how Universal would be able to identify what was damaged without this documentation, doesn't remember when he first notified the insurance company about the leak, or even if he was the one that reported the claim, doesn't remember providing documents to Universal, doesn't remember buying any supplies for the AC repairman to make the fix. So I don't even know what that receipt would even show. Does not remember who was helping him with the claim, doesn't know why he waited so long to report the claim and provided no reason for the delay. And I just want to go back to, there is one case that I just want to pinpoint because the Ideal Mutual Woodruff case, which found that 6 weeks was untimely. to report the claim because the damage was known, not the extent of the damage. That's not the important point. It's whether the damage was known, and the damage was known in that case 6 weeks prior, and they found that the 6 weeks timetable was untimely. So like I said, the focus should not be on the 3.5 months. It should be on what happened during the 3.5 months and then prejudice the insurance company from properly evaluating the claim. Lastly, before my time wraps up, I just want to say that there is no argument in appellant's brief related to his failure to provide documentation. It is undisputed. We requested the AC repair notice several times. He testified to hiring an AC repair company. We've asked for that document. It was never provided, still hasn't been provided. That alone is a post-loss obligation that he did not comply with. So I want to thank you, Your Honors, for your time. And that's the end of my presentation.
And you want us to affirm, right?
Yes, and I would like, with
Okay.
1 second to spare, I would like Your Honors to affirm the trial court's decision and uphold the summary judgment. Thank you.
Just in case Judge Harris wasn't clear. Okay, thank you, counsel. All right, Ms. Berger, looks like you have 541, Rebel.
I'll try to keep this brief, Your Honors. Going back to the issue that we believe to be dispositive in terms of the pleading deficiency here, the fact that the Gottschalk case involved a plaintiff's motion for summary judgment is completely irrelevant. The issue there was that the defense as pled by the defendant was insufficient to prevent the entry of summary judgment. So here we have a defendant who's moved for summary judgment, whose defense should not have been found sufficient to support a summary judgment because it was improperly pled. The same issues that the Gottschalk case decided in terms of the sufficiency of the defense should apply here. It's not sufficient to support a summary judgment or prevent a summary judgment if we were moving for summary judgment on our issues.
Well, isn't it true that if it's, don't we have case law that basically says that if it's not sufficiently, that this affirmative defense is not sufficiently particularized under 1.120C, that you as the plaintiff aren't even required to comply with the conditions proceeding? The defendant can't require that you comply with the conditions proceeding?
Yes, and I was looking at the Cook case that I cited in one of my briefs, and I'm sorry, I can't remember if it's a reply or the answer brief, initial brief, but that case pretty much says that, yeah, when you waive it, you don't have to prove compliance with it. And that just, sorry.
Right, I mean, and there's actually a case in 2017 from our court called Don Fecciobini Inc. versus Huff Roofing Inc. Signed 225 Southern 3rd 323. Now federal Judge Berger wrote the opinion. Pretty good panel on the court though, at the time of that opinion.
Was it Cohen and Harris? Just
Oh, gee, I wouldn't say that if that was that.
kidding.
No, was that Lambert and Wallace guy?
Yeah, if it didn't include Lambert, that comment would never have been made.
Right.
Of course. And I just want to point out, Your Honors, the difference here that is made in terms of a general denial of a compliance with specific, conditions precedent and a specific denial. And we have the Gottschalk case on one hand and the Samaru versus Wells Fargo case from this court as well on the other, where same issue, but in Samaru, the defendant pled specifically failure to comply with a certain paragraph of the contract. And in that case, that defense was specifically pled under 1.120C to find that summary judgment was not supportable in that case based on.
Ms. Berger, how are you going to prove this case? If we rule in your favor, I mean, how do you possibly prove this case?
Well, Your Honors, it wasn't my client's burden at summary judgment to prove his case.
It will be a trial.
It will be. And as we've argued, these issues are for a jury to decide. If he comes to trial with additional evidence, then, maybe there will be a different outcome. But these were issues that should be decided by a trial court, by a jury, because
he doesn't remember who made the repairs, when they were done, what the repairs were. I mean, what additional evidence are you going to come up with?
Your Honor, I'm not his trial counsel. I can't answer that question. But what I do know is that procedurally, the summary judgment should not have been entered based on the pleading deficiency before the court and on the record. And that's a due process issue.
Well, following up with what Judge Cohen is saying, so let's say we reverse and remand for further proceedings. In light of the Supreme Court's recent missive here about we've got a new federal we're going to apply the federal rule, summary judgment here, I mean, doesn't the defense, aren't we just delaying the inevitable? The defendant is going to wait till May 1 and file another motion for summary judgment and saying, okay, how do you possibly prove this? And it seems like our Supreme Court says the judge can make further inquiry instead of the old, is there the slightest doubt that something exists on the record that may lead to there's a disputed issue of material fact. I mean, so.
Perhaps, and, luckily for us, that's not this court's standard of review. And, we're not operating under the new standard that's going to be in place prospectively in May. And perhaps trial counsel is going to have to do some extensive legwork here when your honors reverse. But again, we're talking about a procedural issue that should have prevented the entry of judgment to begin with. And we would request that your honors find that issue dispositive and reverse for further proceedings. Thank you.
Okay, all right.